But again, I just, in the grand scheme of the things that we're dealing with here today, I don't believe that placing her in jail is good for her or for society or for anybody.
We are on the record in both 2023 TR 941 and 23 TR 3158, each captioned State of Kansas versus Shannon Rose Doherty. Please announce appearances.
Jared Regier on behalf of the state.
May it please the court, Ryan Gearing for Mr. Doherty, who also appears in my office via Zoom.
I believe at least one of those, starting with 941, involves a request or bench warrant, that is, to show cause why the defendant's probation should not be revoked. And that one alleges that the defendant has failed to refrain from possessing or consuming alcohol or drugs. And in the other case, 3158,
I believe the allegations, Your Honor, are the same in both cases.
it would appear, and I noticed that Christine Donovan, the probation officer, is here as well.
Your Honor, I also filed an addendum on those cases on November 12th.
Okay, and that's the one that talks about the new pending case for driving while suspended, 24-2302.
That's correct.
She failed to obey the laws, failed to refrain from driving unless legally licensed. So now she has a third case, and I don't have it on my docket yet, but it's apparently 24 TR 2302. Miss Donovan, what is that, a driving while suspended to it, did you say? Yes.
That's set, I show, for December 4th, Your Honor.
And Your Honor, I have retrieved the file for that case. I am showing that the summons that was filed in that matter does appear to have that December 4th date attached to it.
All right, so of course, Ms. Doherty does have a right to contest these allegations and have an evidentiary hearing, and that is obviously why Ms. Donovan is here in part. So, Mr. Gearing, how does your client wish to proceed?
Your Honor, I've discussed with her a right to an evidentiary hearing. She wishes to waive that. She wishes to admit that she's violated her probation in regards to, I guess, both the warrants and the addendum that was filed.
Okay. Ms. Doherty, is that right? You understand that you can challenge these allegations and make the state try to prove that you violated your probation through an evidence hearing?
Yes.
And knowing that, you wish to waive your hearing and stipulate or agree that you violated your probation as Ms. Donovan alleges?
Yes.
I'm sorry?
She said yes, Your Honor.
Okay. And you do that knowing that it is possible your probation will be revoked and you would be remanded to serve your sentence?
Yes.
Yes, okay. All right, well, I will accept the defendant's waiver and stipulation. I do find she's violated probation in both of these cases. Mr. Regier, any recommendations?
One moment, Your Honor. In 23 TR 0941. The defendant did enter a plea of no contest in April of 2024 to a Class B driving while suspended, and the court did order 12 months reporting probation with court services and a 6-month underlying jail sentence. It would also appear that from that same date in 23 TR 3158, the court did order a 6-month underlying jail sentence with 12 months reporting probation with court services, also for a Class B DUI. It would also appear that the court did enter orders about those cases running concurrent to each other based off the journal entries. I am showing that on May 29th of 2024, in both cases, it would appear that a waiver of right to probation hearing was filed with the court in both matters, and that a 2-day sanction in the Butler County Jail was ordered. Based off of that, the state would be recommending that the defendant receive credit for time served, as would be required for the case law, but be revoked in order to serve the sentence as initially ordered. The state would not object to the court continuing its orders about the cases being run concurrent with each other.
Mr. Gearing, your recommendations or position?
Thank you, Your Honor. Your Honor, obviously, Ms. Doherty has an issue with alcohol. You know, as practitioners in the legal system, we all understand that people have issues with that, and that it's not an overnight fix. So procedurally, I don't know how much the court remembers about this, given that it was some time ago. She entered a plea and was sentenced on both of these cases at the same time. And then ultimately, on these violations, she was arrested, put in jail, had to bond out. Both of the warrants didn't get cleared when she got booked in. So then a couple of days later, she was arrested again on the same violation, was put back into the jail, had to bond out again. Since then, Your Honor, I don't know if you remember from our last court appearance, she had been wearing a scram bracelet. She hadn't had any violations on that. She's currently in the Kansas Nurses Assistance Program, is being tested regularly, hasn't had any further issues. My understanding is that she's been reporting to probation as directed in the interim here, hasn't had any other issues. In regards to the addendum, she had been waiting on the Department of Revenue to approve her for her interlock device, which she did receive now, and has an appointment scheduled for later this afternoon to get that installed, which I don't know what that will help us for as far as the case that's pending on December 4th. But from our position, Your Honor, certainly putting her in jail isn't going to do anybody any good. You know, if the court feels that a sanction is appropriate, we certainly understand that. We would ask that you perhaps consider some house arrest to allow her to maintain her employment. You know, she's been doing very well lately. And like I said, you know, when people have substance abuse issues, it does take some time. Certainly she fell off the wagon. She's taken the steps to correct that. She's admitted her fault. And I don't think that there's any reason to put her in jail, Your Honor. Thank you.
Thank you. Ms. Donovan, would you like to say anything on disposition?
Your Honor, just letting the court know that she did complete outpatient treatment in August of this year. And she has been compliant with reporting. She did have a UA recently on November 19th, which was negative. She has made some progress. She had a rocky start when she started probation, but she thus far has been doing what she needs to do. So I would leave it to the court's discretion as to what kind of jail sanction or sanction she should be required to serve. However, as the county attorney mentioned, she already has done a 2-day dip. That was not for this violation. That was for a prior violation.
Okay, thank you. Ms. Doherty, it would appear that your first DUI among these two cases was January 1st of 2022. And it took us so long to get to court that you picked up 2023 TR 3158 just almost a year later, September 13 of 23. And now here we are, about a year later. And you've picked up 24 TR 2302. Now, as I understand that, that's driving while suspended because you didn't have your ignition interlock. But, and it wasn't DUI, so I guess one could say that's progress, but it's not really progress enough. Now you still have a right to trial on that, and you're still presumed not guilty on that new one, but you've already had one probation finding, violation finding. At this time, I am going to order that you serve your 6 months on both cases, which were, you had the benefit that they were run concurrently at sentencing. Otherwise, you'd be serving a year in jail, but 6 months with credit for all time served, however much that comes to. And you're in Wichita now. I will give you to 1 p.m. to be turned into the Butler County Jail at this time, or on this day.
Your Honor, I would request, I don't know, does Butler County have a work release program? Miss Doherty is employed. I mean, obviously, if you put her in jail, it's going to cause her to lose her employment. She's been doing very well. I would respectfully request this court to consider house arrest or something else, because, you know, I understand completely that she got off to a rocky start with this, and she will fully tell you that she has a severe problem with alcohol, as evidenced by these cases and by her starting off on probation. But she has gotten her ducks in a row. As far as being in front of this court, this is the first time that we're in front of this court on a violation. I understand that there was a previous quick dip, but I think that, you know, in the grand scheme.
Well, that was not for probation violation. Was that part of her sentencing?
No, I'm saying that it wasn't, we didn't get before this court. That was done through probation.
Okay, she voluntarily, she did it
No.
instead of, okay.
I think it's a pretty drastic leap to go from a weekend to 6 months when she has gotten it together after that and been doing what she's supposed to be doing, absent the driving issue, which I trust that we're going to get dealt with. Like I said, she has gotten approved, and she does have the appointment scheduled to get that ignition interlock device installed in her vehicle.
I think she was supposed to do that probably in 22 for the first one and 23 for the second one. I don't think they have to be convicted for that.
In the way that her case is played out, Your Honor, we had to wait for her approval to get her suspension changed to a restriction, if that makes sense to the court. So that has been done now, and she does have it scheduled to get installed. You know, obviously, she understands she wasn't supposed to be driving. You know, as the court pointed out, you know, there was no alcohol involved, which, like the court said, is good given the nature of the previous cases. I guess my point is, Your Honor, she's been reporting as directed. She finished her treatment. She hasn't had any more episodes. She's in the assistance program. She's doing everything that she can do after the fact to solve these problems and make sure that we don't have any problems going forward. I just don't think that 6 months in jail is appropriate for what we're dealing with here.
She was charged with driving while suspended June 16th to 24th. So she didn't make it a full year since sentencing on that, before she had contact with law enforcement again. I, as many people do, take driving under the influence very seriously. And she had not one, but two. And for whatever reason, they were dragged out for quite some time. And
I mean, realistically, Your Honor, I mean, you can put her on house arrest for a year if you want to. I'm just asking you to do something other than jail so that she can maintain her employment.
where does she work?
One second. Your Honor, she's a nurse at the El Dorado Correctional Facility.
Nurse at the El Dorado Correctional Facility with 2 DUIs since 2023 and a pending criminal B misdemeanor. Mr. Regier, anything you want to further want us to be heard on?
Your Honor, what I would tell the court is that prior to making my recommendations, I did not have the opportunity to communicate with either CSO Donovan or Mr. Garion regarding this matter. Based off of new information, again, I cannot speak to any information concerning an upcoming appointment concerning ignition interlock device. The state would have certain concerns. Certainly, if based off of what has been said on the record today, the state would be prepared to accept a sanction. The state would respectfully suggest that a longer sanction would be appropriate, up to and including 30 days based off the particularized facts of this case. But the state would not be recommending, as previously indicated on record, any modification to the court's original orders concerning the sentence in this matter.
So what made you change your mind on your recommendation?
Based off of recent statements in this matter, Your Honor. But again, the state, if the court is prepared to order a sanction at the very least, the state would be prepared to recommend approximately 30 days. But the state does believe that under these circumstances, it is not appropriate to make any modification insofar as the length of the sentence is concerned.
So is it the fact that she works at the prison? Is it the fact she's a nurse?
Quite, Your Honor, I have no
The fact
personal.
that she started doing better between the arrest and her first appearance on the new case?
Your Honor, I have no knowledge as to the defendant's current employment status, but based off the statements made by CSO Donovan concerning recent progress in this matter, the state would be prepared to agree to a 30-day sanction, but the state is not recommending any modification to the length of the sentence itself.
I guess what I would say on that, Your Honor, I just had a chance to briefly speak with Ms. Doherty again. For what it's worth to the court, and I appreciate Mr. Regier saying, with the assistance program that she's in, the nurse's assistance program, if you send her to jail, she's going to lose her nursing license. She has to report every day and be prepared to give a UA every day for that program. So like I said, I appreciate what Mr. Regier is saying. I guess what I would ask the court to do as a sanction, if the state is asking for 30 days, is put her on house arrest for 30 days. That way she can continue with her program. There is some punishment. She's allowed to keep her employment, her license. So she's doing very well now. Let's allow her to continue on that path.
Life-threatening offense.
Understand that, Your Honor.
Not once, but twice. And now she can't say that it's the addiction because she's still allegedly violating the law.
Not from substances, Your Honor. Well, I understand what you're saying.
Yeah, but still, that maybe in some ways that she's got no legitimate excuse to. I'm ordering that she serve her sentence in both cases concurrently.
And Your Honor, is the court still ordering that the defendant receive credit for time served on both cases?
Yes, and that she submit herself as told.
Very good, Your Honor.
Can she do house arrest for 6 months, Your Honor? Does the butler, do they have a work release program?
I would say check with the jail about the work release. That's just, from the prison, that's only about what? Is it a half a mile, a quarter of a mile? I would say that the jail can probably work with her on that if they want to, but
With all due respect,
I will authorize it, but I'm not going to order it. I don't think it's appropriate to order it. But I will certainly authorize work release.
And Your Honor, for purposes of the journal entries, the court ordering that work release shall be authorized if it is available.
That's fine. That's fine language. Yeah.
Very good, Your Honor.
I don't mean to beat a dead horse, Your Honor, but my understanding, and speaking from Miss Doherty, is that if she is in jail, she can't comply with her program, and she is going to lose her license and therefore her employment. So I don't know that work release does anything for anybody. I would
Even with house arrest.
request one more time that you put her on house arrest for a year if you have to. I don't care. But that, if you put her on house arrest, obviously there's consequences for her actions. She can continue with this program. She can go to work, but for all intents and purposes, you know, if she's not doing treatment or checking in or going to work, then she's at home. She's not a danger to anybody while she's at home. There hasn't been any recent issues with substances. We're going to have the driving issue figured out as of today. Okay, so that she has valid privileges with the interlock device now. As soon as she has it installed, she will be valid to drive. And I understand that's taken longer than it should have. But again, I just, you know, in the grand scheme of the things that we're dealing with here today, I don't believe that placing her in jail is good for her or for society or for anybody.
Well, she had two chances in that she had two cases and she was granted probation on both. And neither was treated as a second, which it could have been based on conviction dates.
I certainly understand that, Your Honor. Like I said, those are both dealt with simultaneously at the same time.
And then she had a violation that was dealt with by sanction.
Of course.
And
And she will fully tell you, I mean, she has an issue with alcohol. She got off to a rough start. She had a hard time getting through that, but she is doing well now. And I think there's something to be said for that.
So what all is involved in her agreement with the nursing board?
I have to check in every day. At any day when I check in at 5 a.m., I'm told whether or not I have to submit a drug test that day. I have to do meetings twice a week, AA meetings, and submit those to the KNAP program. And I also have monthly meetings that I have to do every third Monday of the month with my KNAP group.
All right, the deputy at the jail, can you unmute there? I know you're here on a different defendant, but could you offer me a couple answers to a few questions?
I can try, ma'am.
All right. Do you have a work release program?
It has to be authorized through the jail administrator, I believe.
No, that's what I was thinking too. And you do have AA services at the jail?
AA and NA do have programs. I'm not sure how active they are at this moment.
Okay. So I think that would take care of two problems right there. If she can convince the administrator why she should have work release, and if she can complete her AANA there at the jail, and then work
I don't
on
know.
the other program.
Access to a
maybe.
telephone at 5 o'clock in the morning. I mean, I don't know the answer to these.
Well, if she gets work release, the jail's gonna be giving her routine evaluations to make sure she's not using.
No, I understand that, but I'm talking about for purposes, if she doesn't check into that program every day, the nurse assistance program, then she will be removed from that program, which means she no longer has a nursing license, which means that she no longer has employment.
Well, sometimes there are normal and probable consequences to voluntary actions, and that may be what she's looking at. What kind of nursing degree does she have?
I have my LPN.
LPN?
Yes, ma'am.
Well, that is my order, and at this time, you need to comply.
What is your order?
That her probation is revoked, and Jen, did I give her till 1 o'clock today?
Yes.
1 o'clock today to surrender herself to the Butler County Jail, and she can work with them in the prison to see if they want to give her work release. And then, of course, she'll need to work with her nursing board.
Understand.
All right. We'll be in recess. Thank you.
Hey guys, it's Sam from Legal Livewire. As someone who's personally lost a loved one to a drunk driver, I totally understand the judge's harshness. But does this decision truly serve justice or rehabilitation? Let me know your thoughts in the comments below or join me on Discord. You can find the link in the description. Thanks for watching.